Hi, everybody, and welcome back. I want to today start a series of discussions that focus on the way psychiatry was expanded in its role in the courtroom. We're talking both in these series of discussions about psychiatrists' role in treating patients, trying to decide what the problem is, what to do about it. But we're also talking about another central part of my work is the role of psychiatry in the courtroom, and my belief that we really don't contribute except in selected situations where the issue is not the state of mind of an alleged victim or of an alleged perpetrator, but of other things that we can do. But we want to talk in these discussions about psychiatry's presence in the courtroom. And that role started to expand from what it traditionally had been in the 1950s through the work of some very leading forensic psychiatrists. And I'd like to tell you a little bit about that. Before that time, the main situation where psychiatrists would be called in criminal trials was the insanity defense. And it was never an everyday thing, but nonetheless, it still had an influence on the thinking of how trials should be held. And basically, the insanity defense was if you didn't understand that it was wrong when you did it, or even if you did understand mental illness prevented you from controlling yourself, then supposedly you'd be treated differently. The theory was you wouldn't be punished, you'd be treated. Of course, the theory was not honest, because it's not as though somebody would be released who was found legally insane. They would be confined in a different facility maybe. But they were nonetheless being imprisoned. So it wasn't really honest. But nonetheless, psychiatrists wanted to expand the role, or at least certainly leading people in the field wanted to expand the role. And so they had this idea that instead of just having a yes or no test for responsibility for your behavior, insane or sane, legally sane or insane, there should be what they call diminished responsibility, a graded system of how responsible you were. And that therefore the response of society would be graded according to what the court decided your degree of responsibility. To the degree mental illness interfered with your ability to be responsible for your behavior, you would be more suitable for a treatment response rather than a punishment response. And I want to illustrate the process by which this expansion took place using the work of what I call the best and the brightest. The people with the best reputations who would consider the leaders. Because if they did things which we can now look back on and clearly understand that they were not acceptable way to change the law, it'll allow us to do a better job in today's world when the best and the brightest tell us what we should do, whether it's in the courtroom or in the therapy setting. So I'm talking about the expansion from just the insanity defense to what came to be known the diminished capacity defense. And that there was an attempt to change the law so that you could bring in psychiatrists even though you did not enter an insanity defense. And there were two figures who really were very prominent in this. One was a psychiatrist, Dr. Bernard Diamond, and one was an attorney, Dr. Charles Garry. Both were very prominent. Dr. Diamond was not only a psychiatrist in practice, but he was on the faculty of both the UC Medical Center, University of California Medical Center in San Francisco, and the law school, very prestigious Bolt Law School of the University of California at Berkeley, professor of criminology. And you had Charles Garry, very prominent, sort of left-oriented lawyer representing a lot of causes that would be having to do with labor issues and so forth. And Garry and Diamond collaborated to find a way to find cases that would allow them to influence the courts to change the rules. and develop this new defense. And let me just quote you something from Dr. Diamond to illustrate how this was a deliberate strategy that really raises questions. There was a trial that I'm going to tell you about soon of a man named Nicholas Gorshin, and the way Diamond described it, he said, "The trial of Nicholas Gorshin was carefully planned from the very beginning to utilize to the fullest possible extent psychiatric evidence to disprove premeditation and malice aforethought. When Nicholas Gorshin shot and killed his longshoreman boss, the lawyers and the psychiatrists, so to speak, were ready and waiting for him." So what that means is that they were looking for a case where they said, we can argue that even though he wasn't legally insane, he didn't have the ability to premeditate. He didn't have the ability to have the intention to kill. And that those issues would now be part of a trial. And it'll expand the role of psychiatry in the courtroom. So this process took about 10 years to really mature. The first trial was not of this man Gorshin, it was another man by the name of Wells. He was a prisoner who had committed a crime that called for life imprisonment. And during an altercation with a guard, Wells got so mad that he picked up like a spittoon or something like a wastebasket and threw it at the guard and actually did hit the guard and was some injury. I don't remember how serious. So according to California law at that time, he could get the death penalty if found guilty of throwing this trash can, the relatively minor injury resulting. So that seemed to be extreme in some people's minds. I certainly would have agreed if I were there. And so they held this trial, and they were able to convince the court that he shouldn't get the death penalty, that he was in a compromised mental state because of the turmoil of the argument that had been going on. So it kind of set a precedent of a minor sort in 1949. 10 years later, there was another trial of a man named Nicholas Gorshin, which finally did the trick of what Garry and Diamond had planned all along. Let me quote you again. This is Dr. Diamond writing in the Stanford Law Review, so I'm not making up my own version. This is what Diamond said when he examined Nicholas Gorshin, a man who worked on the docks at San Francisco, had been drinking and was ordered to go home. And he didn't like the fact that his boss did this, so he came back with a gun, and an altercation ensued, and he shot and killed him. So this was a case in which they thought they could convince a court that Nicholas Gorshin, like Wells, also was in a compromised mental state, even though he was not anything that would indicate he was legally insane, meaning he didn't even know what he was doing. So let me again quote from Dr. Diamond, who says, "When I examined Gorshin, there was little or no evidence of mental illness, but I was alerted by two facts. One, that the crime was completely out of keeping with the defendant's previous personality. And two, that his nickname had been for many years Sleepy. Out of these simple clues, there developed a strange and fascinating story of a secret mental illness, which had never before been revealed to even his closest friends or family. He had had these sleepy spells for at least 20 years, perhaps once or twice a week. And during those few moments of trance, he entered into a strange world populated by demons, strange animals, and bizarre and deformed people." End of quotation. To which I say that's quite a secret mental illness that was never noticed by anybody. They were able to change the law because he was not found guilty of murder. He was only found guilty of manslaughter. Now that means that when he shot the man, he didn't really intend to kill him or have any recognition if you do that somebody could die. Either one would qualify to be guilty of murder. Manslaughter means that you didn't have any reason to think what you were doing might kill somebody and you didn't intend to kill them, but you did do that, so you're guilty of a serious crime but not murder. So I think what I'm trying to illustrate there is that when psychiatrists engage in this process of what they call an examination, they are free to construct any scenario as to what was supposedly going on in somebody's mind. There's no brakes on it because the whole process is not scientific. It's one human being talking to another. And there you see with the background that I've given you that the motivation that Dr. Diamond had was clearly to change legal policy from the beginning, and as it was with Charles Garry. Well, I'm not against changing legal policy if you do it in the proper way, but not by creating secret mental disorders, which obviously is an invention of the psychiatrist. And the reason that I picked Bernard Diamond is because I wanted to pick somebody with these outstanding credentials, leading member of the profession. And it wasn't too long before the American Psychiatric Association leaders of forensic psychiatry were supporting this kind of process in which they said, this is exactly how it should be done. We should have another form of defense, which ended up being called the diminished capacity defense. So that's what happened. This new defense, which allowed you to say that even though I acted the way I did, I didn't do it in a meaningful and mature decision process. So we have psychiatrists examining people to see whether they acted meaningfully and maturely, or whether they acted with an awareness of an obligation to follow the law. Can you picture a psychiatrist trying to form a scientific opinion about somebody having a meaningful and mature decision versus one that wasn't meaningful and mature? I mean, basically the sky's the limit as for what you're going to get. So it's those kind of cases that I've started seeing in 1975 and very seriously began to be involved in that for about a dozen years. Next time, let's go on and talk a little more about the evolution of this diminished capacity defense with another case that received a lot of attention. And I think we'll be ready to then keep going with other examples of psychiatry's role in the courtroom. Thanks for being here.